Hi, this is Todd Sholar with Smith Sholar Milliken, and last week we talked about some myths with regard to estates. This week we're going to talk about a few truths when it comes to estates. First and foremost, when dealing with an estate, if you're talking to the executor of the estate, that person may or may not be the correct person to sign your documents. Remember that an executor only has authority over the real estate if in fact the will directly says that that executor is to take control of and sell that real estate. In other words, it has to be pulled into the estate by the terms of the will itself. 9 times out of 10, the will does not do that or does not do that appropriately, and so the devisees under the will are really the ones that you need to sign your documents. Remember also that a person is only an executor for an estate when a court says they are the executor for the estate. So in other words, until a court appoints them, they have no authority at all. So to be named in a will doesn't answer the question. That will has to be admitted to probate by a judge, and the judge has to appoint them as the executor for the estate. One last truth is that a will only speaks when it is in fact admitted to probate. So I've heard many times from sellers or agents who have indicated that, well, the will left the property to A, B, and C. And I would ask the question, did they probate the will? Well, no, they didn't. Well, then A, B, and C don't own it necessarily. Until the will is probated, it does not speak, and therefore it's irrelevant. So you have to ask the follow-up questions. If there was a will, was it ever admitted to probate? Next week we're going to talk about just a couple of things for your action plan so that you don't run into any problems with handling estates. Have a great week.